The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome. This morning we have 3 cases that will be submitted. Those cases are State of Iowa versus Lawrence Walker, State of Iowa versus James Mathias, and State of Iowa versus Kenneth Hurd. We'll hear the arguments first in State versus Walker. Ms. Jennisch.
May it please the court, counsel. My name is Nan Jennisch, and I'm with the State Appellate Defender's Office, and I'm here on behalf of Mr. Lawrence Walker and representing him on this appeal. He was convicted of sex abuse and lascivious acts, and we've raised several issues with regard to the rape shield law and the medical exception to the hearsay rule. And I think I'm going to start off by talking about the medical exception to the hearsay rule. In this case, we have 2 healthcare providers who testified. The nurse and the doctor, 18 days later, testified to what the child recounted as far as the sexual abuse is concerned. And in this case, we've challenged both statements. The first, the nurse practitioner, her statements were not objected to, but the defense did object to the admission of the physician's testimony under hearsay grounds. And in this case, it's pretty straightforward, using the Renville 2-part test to determine whether or not those statements fit under that exception, and that is the first being the motive, the purpose for seeking treatment, and secondly, the content of those statements and whether or not they can be really reasonably relied upon for the purposes of treatment or diagnosis. And with respect to the first encounter with the medical professional, that was the child was taken to the ER the evening after the alleged assault. She saw the nurse practitioner. She spoke with the mother first, got the story, child's account, and then she subsequently examined the child, and then who again recounted the assault that took place. And with respect to the statements to the nurse, we argue that there hasn't been a sufficient foundation laid for the admission of her testimony in that regard.
I want to ask you a basic question about the interaction between the child and the nurse. Would you agree with me that the purpose is not just to find out if there's physically or medically something wrong, but also emotionally and mentally?
That is correct. That is true. And again, the argument is more what we have quarrel with is actually under the first prong, that the interactions between the nurse and the child, the patient, there wasn't any discussion in the record that we could see about the nurse impressing upon the child the importance of telling her the truth about what happened, and also telling her the importance of it in that, maybe in such simple terms as, I need to know truthfully what happened because I can help you.
Is the record here adequate to resolve the claim with respect to the nurse? Because my understanding is not only was there no objection, but then defense counsel elicited additional hearsay statements. And it seems like there was some sort of strategy to try to draw out more statements to then show inconsistency. So to the extent that that is true, is the record here adequate to resolve the claim on direct appeal?
I think it is, insofar as I think it is because with the defense really.
Let me add one. Feel free to correct me if I'm wrong.
Yeah.
My recollection of the record was that counsel kept asking more questions and eliciting additional hearsay.
Right, and that was also another issue that we raised in arguing that shouldn't have been done. And as far as strategy goes, I think that not only the defense counsel, the comment that he wanted to elicit from the nurse was that the child indicated that she had her leg broken. Turned out not to be true. That part of her statement, I think, is minor compared to what she claims Mr. Walker did to her the night before, and her being put on his lap. He has his underwear off, gyrating on her, contact, anal contact, vaginal contact. I think the rest of the statements, I think that is far more damaging and prejudicial, and as far as that is concerned.
Well,
but
given his own admissions during the interview, can you show Strickland prejudice?
With respect to the nurse, yes. Again, in reading the closing arguments, defense, he seems to characterize Mr. Walker's statements as confessions, and they're bad. When I look at it, I look at it a little bit differently. He just admitted to limited contact, and if whatever contact there was, it wasn't. He was just.
Didn't he say he touched her vagina?
He did.
Isn't that a little beyond limited contact? She's 4.
Certainly, but he did also, as far as the what he said that he did isn't totally consistent with what she said. I mean, he didn't admit to the worst part of what she revealed to the doctor.
That's not uncommon, is it?
Certainly, that uncommon that defendants are reluctant to admit to
the stories
extent.
may be just a little different, and it gets down to credibility, perhaps.
Right, and it is always an issue of credibility, and it's up to the jury to decide whether they believe him or not, and
or her.
I only bring up the defendant's statements because, as the state points out, the state characterizes the trial more as Mr. Walker before, Mr. Walker after his statements. His statements to the detective versus the statements he makes at trial, in which he basically backtracks and claims that he was pressured to make admissions and also was also under the influence of alcohol and drugs at the time. And again, it's an issue of credibility. It's not like it'd be different. I understand. Overwhelming evidence. You've got, if it's uncontested evidence. But in this case, it's always in a sex abuse case. He said, she said a lot of times. And in this case, there was some forensic evidence, but again, it was inconclusive. So for that reason, the testimony of the physician and the nurse were crucial to the state's case. And I think that with regard to the nurse's testimony, it wasn't preserved. And so let's say we just have the physician testimony. And I think that that is a lot more persuasive, I would argue, before the jury, because the doctor is an expert in the field. And also it's important to consider that the nurse, what are the reasons for the nurse to make a referral to the doctor 2 weeks later? That's where I want to talk about the doctor's testimony. And
What does the record show on who referred or the reason for the referral?
There's only one. There's only one line in the transcripts there, and that is the testimony of the physician, and she testified that the nurse referred her for potential inappropriate genital or sexual contact, something along those lines, and that's what the physician testified to was the reason for the referral, so we didn't get that testimony from the nurse, but again, I would argue that is a significant fact, insofar as it shows that the foundation for the admissions of the physician's testimony
were
is
any of
also
these
inadequate.
healthcare professionals treating physicians or treating healthcare practitioners? Was the nurse a treater?
She, are you saying, does the nurse have a continuing treating relationship?
I'm saying when the mother brought the child to the emergency room, was that for treatment?
Yes. It could be for treatment. And because...
Well, if it's for treatment, isn't a treater allowed to elicit a history and then repeat that history? It's not hearsay?
Certainly. And we have cases that talk about it. But I think the main issue in this particular case is that we still have to make the determination that it's the child. Did the child understand the reason for the visit? It's not so much the our objective characterization of that interaction and that
And was Dr. Hare a treater, or was Dr. Hare like an independent medical examination to confirm or deny that there was sexual misconduct?
Her role is, in this case, was as, like you said, an independent medical exam.
So if a mother takes a baby to the hospital, and say the baby can't even talk, say they're 2 or 3 years old because they have a high fever, and the nurse starts eliciting history from the mother, is that admissible in a personal injury case under the hearsay rules?
So so you're saying that the mother's statements to the medical provider in lieu of the child?
Or let's say the child's 4 years old.
Right.
And the child can verbalize. The combination of the mother and the child's history, is that admissible in a personal injury case? Say there was a car accident. Forget the fever. Car accident, takes the child to the hospital to be treated. Nurse takes the history, and mother and child participate in the history. Is that admissible in the personal injury case under our hearsay rules?
Well, I would argue no, because you can also.
What's the authority?
What's to prevent the mother?
Authority for not being admissible? I mean, what's the case law that said it's not admissible if you're a treater?
But it's the statements of the declarant, right? And is that the declarant? It's not the mother that's the victim, but rather the child, right?
You have a young child. You have both people contributing.
Right. Right.
In this case, we have the child's words, right? Sounds to me like the alleged incident happened, and the very next afternoon, she told her mom some very concerning things, and mom immediately took her to the emergency room, and that's when the little girl told the nurse, it's the girl's words. She used some very startling words that touched my butt crack really deep, and I had my underwear on, so he took them off, and she goes on. Those are her words.
Correct.
At the time of an emergency visit. So wouldn't that be when the nurse heard those words? Let's pretend like the doctor's testimony down the road is off the table. Yeah. If we're just talking about the nurse, because I think the things they heard were very similar. Would you agree with me?
Agreed.
Okay, so let's just talk about the nurse. Is it your position today that what that little girl said the day after the incident is off limits?
You're just talking about, again, that there are two prongs. We have to two-step analysis. And yes, the nurse, her interaction, her questions about what happened, and she said she does that as part of her protocol. Okay, that could be a medical that could be content and statements that the medical provider could rely upon for treatment.
If someone told you that 4 years old, would you be concerned about their mental well-being? If those comments that I said, wouldn't that be alarming for a medical person, even in the mental arena?
Certainly. But again, that's just focusing on the whole, whether or not a medical provider could rely on those statements. And that's really not the issue in this particular case.
That's for the jury to decide whether or not the person was lying to the medical provider or not. And we've held, at least I think we've held, that when you go to a treater and you give them a history, especially in an abuse case, it's important for the treater to get that information so they can separate the abuser from the child.
But in a child situation, it's a little different from, when we're dealing with adults. And for the child, we can't make that assumption that the child necessarily knows why they're going to the doctor, to the ER. And in fact, in this particular case, there's the child, she thought that her leg was broken, and it turned out not to be true. And again, not that she's lying, but that she is mistaken, confused. And so those are some of the issues that we have when we're dealing with child victims, especially ones that are as young as 4, as we have here in this case. I see my time is up.
Ms. Jennisch, thank you as well. Mr. Howe?
Thank you, Your Honor. May it please the court, counsel. We'll pick up where we left off on the ineffective assistance of counsel claim. I believe that defense counsel, our record indicates, was making a highly strategic decision to exclude some medical hearsay evidence and admit others that was favorable to the defense's theory of the case. When we look at the statements that defense counsel elicited and permitted to be elicited by the state, they went directly to attempting to undermine the credibility of EW in this case. The statement that her ankles were broken when medically it was demonstrably not true, to promote the theory that EW's description of the events was evolving as the case went along. I think for 2 reasons, the ineffective assistance of counsel claim will fail at this stage. First, our record is not perfect, but even if our record wasn't as developed as it appears to be already, I think overwhelming evidence establishes Mr. Walker's guilt in this case. And the reason I say that is if you haven't already, I encourage you highly to watch the interview video in this case. I think his admissions to the detective in conjunction with EW's statements to not only the nurse, but if we were to exclude that, the medical practitioner, Dr. Har, and her own statements at trial are damning evidence of Mr. Walker's guilt.
Let me ask you about United States v. Renville, which is a case that she largely relies on. Excuse me, I'm a little under the weather. I hope you can hear me.
All right, I can.
Yeah. The argument is that Renville has a 2-prong test.
That's correct.
And it seems like that's correct. I mean, the 1 prong is that the person making the statement must be motivated for treatment purposes. And the 2nd prong is that the statement must be reasonably relied upon by the treater. And I take it you accept that as the proper framework for...
That is the framework that this court adopted in Tracy, Your Honor.
Right.
That's correct.
Okay. So the question then becomes, with a young child, how do you establish prong 1? How do you establish what the motivation of the child is in the forensic setting?
Absolutely. I think it would be done exactly as it was in this case. And do you have more?
Yeah, I do.
Oh, please continue.
And ordinarily, I think, a forensic interviewer spends considerable time explaining to the child the purpose of the interview. In fact, pretty much to establish prong 1, that we're here for your well-being and blah, 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 and all this kind of stuff, and try, did that occur here? Or what kind of evidence do you have that prong 1 has been satisfied?
Sure. If you look at the statements from Dr. Har, she explained to the jury in her testimony that she meets with child witnesses. She explains her role. She says that she takes care of little kids to big kids to high school kids, and demonstrated that her role was as a medical practitioner, as a doctor. She asked the child if the child understood what the role of doctors were, and the child responded, "I like doctors just fine. I don't like shots." I think at that point we've established the first Renville-Tracy prong, which is that the child would have understood that her statements were for the purpose of medical treatment. The second part was also satisfied, which is that the statements that she made were for the purposes consistent with medical treatment. In addition, this court has found that it's not exclusive to medical, especially in the context of child sex abuse. There's not only counseling, but psychological concerns that we may have. And part of the first step of treatment is an intervention between the child and the assaulter.
I don't have any problem with the second prong. I don't think it's the first prong that I have the most interest in. Now, if a statement is made that contains hearsay upon hearsay in the context of a forensic interview, how is that treated?
I don't believe that would be any different than any other hearsay claim. We would look, for example, another hearsay rationale. This court has held that the residual rule oftentimes can help provide a little bit of flex in this area, because we're dealing with declarants, complaining witnesses who may have difficulty explaining what has occurred to them, and this fills a gap. Additionally, depending on context, if the child is sufficiently upset, other hearsay rationales might permit their admission.
I wanted to ask you about a recent, within the last few years, decision of our court. A couple of us dissented, but the majority of the court held that in the context of a domestic violence victim, that for the individual to describe her injuries, symptoms, things like that, fell within the medical exception, but identifying the perpetrator did not. How do you deal with that State versus Smith decision?
Certainly. I don't think Smith really affects the outcome of this case. The majority opinion in Smith describes how it's not a per se rule of admission in the state of Iowa. I don't take much trouble with that. I think it's at present a context-based decision, and we look at the factors and if there's been enough foundation to support the admission of the statements. However, I think there is a distinction that is worth noting, and I think the dissent pointed that out aptly, which is that when we're dealing with child sex abuse victims, it's a little bit of their motivations are different than, per se, an adult who's reporting domestic abuse. They lack, I would suggest, the improper rationales that the hearsay rule might be concerned with to set someone up or to shift blame. A child, frankly, I don't think has those Machiavellian tendencies.
Do you think it would be reasonable to assume regarding prong one, which is a person makes a statement, whether they're motivated for treatment, a girl telling mommy what happened? Could you interpret that as perhaps a form of requesting treatment?
It's possible. I think it is possible for a couple of reasons, which is that children aren't in control of their lives. To a large extent, when you're of a sufficient age, what happens to you is dictated by your parents or guardian. And if that's the case, then obtaining treatment, your first step would be to tell your parent.
Isn't Smith also distinguishable in that it involved an adult victim, and here we have a child, and the identity of the perpetrator is important to treat the child, as you and Justice Wiggins have pointed out, to separate the abuser from the child.
I completely agree with that statement, Your Honor. Again, as I've mentioned, children don't have full control of their lives, and if we're going to treat an instance of sexual abuse or violence against a child, the first step is to find out who. Turning to whether or not the district court correctly excluded evidence under Iowa's Rape Shield Act of a vague allegation that something else might have been going on with E.W.'s brother, I think the district court made the correct call in that instance because there was an underlying inference that some abuse must have happened earlier and it must have been the brother. And in that instance, this court's case of Jones comes squarely into play. The definition under our Rape Shield law of other sexual behavior includes prior acts of sexual abuse. Because that necessary inference existed, the district court was correct in excluding it. And even if this court were to take issue with that, I would note that it was minimally relevant at best and was outweighed by its distracting nature in the context of the trial. turning to Dr. Haar's statements, no objection was raised to the foundation of her testimony and that her credentials as a practitioner, both as a clinician as well as therapeutic, was raised. EW remained a patient of Dr. Haar up until the time of trial, where she was continuing to receive treatment. I think that, again, supports both prongs of the Renville test, that her statements to the doctor were for the purposes of treatment and were in anticipation of treatment. And again, the evidence in this case was overwhelming. There's really no way around it.
Have you had a chance to look at the case law on 4-year-olds giving information to medical providers? And have you, well, let me just leave it that way. Have you had a chance to do a canvass of cases involving 4-year-olds?
A canvass, no, Your Honor. I would say my research was devoted largely to this state because I think the state's law on the issue was clear.
I mean, one could argue that In re JC is a pretty relevant precedent, even though it's confrontation, because confrontation issues somewhat wrap into medical diagnosis. But it was 4-year-old and Dr. Haar.
Certainly.
And we allowed the testimony.
In preparing for this case, in reviewing JC, I came to the same conclusion that because it largely dealt with the confrontation clause and because Mr. Walker expressly disavowed any confrontation clause in this case, I agree with you that several of the underlying principles are in play, but I think...
Well, if it falls within a traditional medical diagnosis exception, then it's not going to be testimonial, right?
Sure.
So there is some overlap between the
I would
two
agree.
theories.
For the foregoing reasons, the state would ask that you affirm Mr. Walker's convictions on both crimes. Thank you.
Mr. Howell, thank you as well. Ms. Jennisch, you may present your rebuttal.
First, I wanted to address the concerns raised by both Justice Apple and Justice Waterman. First of all, we're really focusing on the physicians. Your question was directed more at the physician's examination, and I believe you indicated that you really didn't have a problem with the second prong of the test insofar as the whole whether or not that could be for treatment. And well, I think this case is different because the physician was actually consulted 18 days after the initial examination.
Yeah, but knowing who the perpetrator was would be relevant toward treatment, wouldn't it? I mean, you're looking for the well-being of the child, and you know.
But in this case, the nurse did everything. Pretty much did the same.
Oh yeah,
Well,
that's
Ms.
not always.
Jennisch,
Look.
you can save your voice.
Yeah.
You know, it is the test that we've gone through, picked up from Renville. We did it in Tracy, and we applied it again in Smith. Is it as stringent as you're trying to argue here? Is it, in fact, as already has been pointed out, there certainly is. There are judges that think that the test doesn't even really need to be applied, and there should just be a per se rule, just to avoid this. So, aren't we really just identifying some basic premise that the child or the victim that comes to an emergency room for treatment understands that, as the doctor said, I'm a doctor, I'm here to help you. And so doesn't that get you over the first hurdle? If there's at least some evidence that the child understands that this is someone that a doctor and I'm going to help you.
But what you're referring to is what is told to the child, and it's also a subjective. You need to, if there's any evidence that the child really did understand.
Sure. I mean, the child says, I don't like shots. I mean, so the child knows the context.
She knows the context, but can she make the link between how important it is to be truthful?
Do you think a 4-year-old is supposed to call the doctor's office and make an appointment and say, this is what I have going on? And I think that's a ridiculous thing, of course. I think you'd agree.
Sure.
But on the other hand, also, who took her there? Her mom, who she probably trusts more than anybody in the world. Doesn't prong one seem pretty simple in a case like this?
In a case like this, certainly, and as the case that we relied on in terms of, getting that information, the child's understanding, that doesn't have to come from the child. That can come from the parent. That can come from the provider. And there wasn't a sufficient foundation in that respect.
Can I clarify your claim a little bit?
Sure.
As I understand it, your specific argument isn't necessarily that the child's statement of identity. That's really not what you're challenging. Your challenge is broader than that the child's statements for treatment should not have been admitted, period.
Right.
Because there wasn't sufficient foundation for the first prong of Renville.
Correct. And there was discussion, and I wanted to address Justice Waterman's concern about Smith. And again, the majority in that case, and I understand you were in the dissent, but that there really isn't a categorical rule that in child abuse cases that the issue of identity is always pertinent to treatment. But in this case, it's a sex abuse case, shares a lot of similarities, but the perpetrator in this case was an uncle who didn't live there, wasn't a member of the household. In fact, in reading the doctor's testimony, she specifically stated that she does ask those particular questions, and for that reason. And the child kept referring to this Chris, and he smokes, and she's like, "Well, is Larry in the house?" No. And so, for that reason, we don't have the same concerns about keeping the child safe from the perpetrator. Unclear record how often Mr. Walker interacts with her, but I think that's an important distinction to make.
Isn't that cross-examination? Couldn't that be found out in cross-examination?
With what respect?
You're talking about those discrepancies. Who are you talking about, the smoker or Larry? That's what cross-examination is all about, isn't it? Trying to get to the bottom of the testimony?
Certainly. But I guess how it...
Trying to keep it out completely.
Right.
And the fact that it went in, a defense attorney would have an opportunity to challenge it, right? On cross-examination?
Certainly.
And those are the opportunities that they would have to try and ferret out the credibility of whether it be the child's statement or the nurse or whoever.
Certainly. But again, if it doesn't fit within the exception, I think that it should just be excluded. And I would also urge the court, again, I know that the Smith decision is really recent, but that, of course, that dealt with an adult. But again, I think the court was concerned in that case that we still need to make a foundation for that case. And also there has to be some evidence, testimony presented to show the importance, why is it important to identity of the perpetrator for purposes of treatment. And obviously we don't have that in the record here either, but I think that's something to consider. And for those reasons, we ask the court reverse his convictions for sex abuse and lascivious acts. Thank you.
Thank you as well, Ms. Jennisch. Mr. Howell, thank you again. The case of State v. Walker is now then submitted. We'll next hear the arguments in State v. Mathias.